Mark Cohen, so you served as the IP attaché in Beijing and as the senior counsel for the US Patent and Trade Office for a while. So, in the career that you've been following these IP issues, how would you describe China's trajectory or change on IP issues up until now?
So first is IP is clearly part of China's industrial policy and economic planning, and that's overt. That began around 2008 with the National IP Strategy, but it's reflected in a range of other documents besides the NIPS, including a range of economic and industrial plans. So this is a game changer in the sense that folks who were afraid that China, like other communist economies or formerly communist economies, wouldn't protect IP because they had a weak notion of private property rights, probably would not have expected that China would not only want to protect IP in its own way, but that it would do that aggressively and integrate it into its economic planning. We've seen in recent years how this has evolved as China has become the most litigious society for intellectual property in the world. The patent and trademark offices are huge, bigger than the next several offices combined. This has been a trend for some time. And we've also seen in certain areas where there's been a divergence from the U.S. The U.S. has gotten weaker or has been under stress in certain areas, and China has actually strengthened those very areas that have been under attack. The three big ones in my mind are patentability, software patents, business method or fintech patents, and genetic inventions. The U.S. has been a string of cases that have weakened rights in those areas. China has taken steps to strengthen and make it easier to obtain patents in those areas. Second, in injunctive relief, we have a doctrine in the U.S. Out of a case called eBay, where injunctions are not automatic in intellectual property cases. China still has a 90 to 95% injunction rate. And the third area is in the courts. China has a new specialized appellate IP court, probably is the biggest indicator of that, but not the only one. That court came online January 1, very much modeled after our own Court of Appeals for the Federal Circuit. Some people think the Federal Circuit is too beholden to patent and IP issues. China thinks this is probably a good thing in terms of improving IP protection and enhancing the status and interest of society in IP and patenting.
Okay, so with trade negotiations sort of ongoing at the moment, what have you seen in how IP issues have been dealt with, and maybe what are your expectations for it moving forward?
Yes, I can only speak about what I've seen overtly. We've seen some legislative changes, even legislative proposals, some of which are good. I think the big ones recently were the foreign investment law and the changes to the administration of technology import-export regulations. The foreign investment law is widely reported, prohibits compelling the transfer of technology in order to obtain regulatory approval for a foreign investment in China. Problem is, I think a lot of the pressure on foreign investors to transfer technology in order to obtain regulatory approval has been informal. A tax incentive, maybe preferential real estate, some other preferential terms, or capitalization of the technology. So that may be a little bit too simplistic to assume that that law by itself will address the concerns articulated by the administration, and particularly because the law does not even have a clear dispute mechanism. I would like to see maybe the IP courts have jurisdiction over disputes arising in that. The technology import-export regulation changes something that I've advocated for over a dozen years, long overdue. I think they are a potentially great benefit to China in making it easier to transfer technology from foreigners, whether it's for profit, not for profit, donated, or even government-to-government collaboration, because those regulations cover all those things. But they had onerous provisions about Chinese ownership of improvements to the technology and indemnities from third-party risks. Those have been removed, so I think that is a very positive thing. There's been other stuff that's a little bit less clearly positive. There was a rule on NDRC and dealing with social credit system and patent infringement. You know, I think the really important thing is to have good courts, good judges, technically competent, fairly administered, transparent, adjudicating these kinds of disputes, special campaigns, unique mechanisms, kind of out of the mainstream of what other countries do. And I think that's where we're likely to see the most improvements.
All right. So lastly, I know in your event today you described the new normal in collaboration between the U.S. and China on IP issues as a half-dammed river. What do you mean by that?
So what we have now is first of all a wider river, a wider and deeper river, and by that I mean in both export controls and in foreign investment regulation, CFIUS regulation. The John McCain Defense Reauthorization Act extended the scope of regulation. So good news is export controls and CFIUS regulation are now closely aligned. So you can't get one out of one what you couldn't get out of the other. That makes perfect sense. The bad news is the lack of clarity about the greater areas of technology that are covered by it. So you have this interest in an explicit authorization to pursue foundational and emerging technologies, or in the case of CFIUS, also passive non-controlling investments. Now, in terms of the technology scope, there's a wide range of technologies there. There's AI, there's 5G, there's stuff that clearly has defense possibilities, and you're going up the technology ladder to an earlier stage where it's foundational. So it's not even dual use. It's a foundational early stage, pretty close to fundamental research, although the regulations don't use that term because that's really the domain of universities and international collaboration, and when there may not be any practical application. So you're going further upstream to a time when it may not be clear whether a particular experiment has any useful application. There's a lot of experimental failures out there, particularly in areas like biotech. How do you regulate that? How do you regulate experimental failure where there's no use, but there's practical value? That's a problem in terms of how they define that scope and whether it really varies from sector to sector. You know, anything in the life sciences is a bit unpredictable. We don't know all the mechanics, the laws of nature that govern life forms. In physics and mechanical arts, a little bit more predictable. Maybe you're closer to it, but you still may not know whether there's a defense application. So that's the bigger, deeper river. That's the world we're living in now. An effort to control more technologies. And there's a potential downside, not just in the lack of clarity, but in reducing collaboration, duplicating R&D efforts in different markets, even in markets where we have good relations and close collaboration, that now those may be more restricted out of concern for violating these rules. Bigger river, deeper river. Uncertain dimensions, but bigger. Now you have this question about how big is the dam? Do we have that dam sufficiently constructed to contain this additional high flow of water, however indeterminate it would be? And I think we have a dam that's not complete. And of course, if you have an incomplete dam, to continue the metaphor, the water is going to come out at high pressure wherever there's a leak. Where are those leaks? Well, the first leak is in multilateral controls. If technology is available, whether through licensing or through weak IP regimes or through weak export controls of foreign investment regimes from third markets, then the technology will be acquired from those other markets. That's the first weakness, the multilateralization. The other places where I think you're going to see increased concern because of the scope of the dam is in employee mobility. Employees who have decided, gee, it's getting tough for me to work in this environment. I'm being suspected of doing things that are inappropriate. I always wanted to go back to China anyway. They're offering me a good lab. There's a 1,000 Talents program, whatever the incentives are, legitimate or non-legitimate. And they may feel like, okay, now's the time to go. We hear all these stories about, a senior tech person heading back to China. They may not put it all on a USB drive, but they may know a hell of a lot about what's valuable, where the competitors are headed, et cetera. So that's going to put pressure on people to think about when they leave, particularly if it's unclear about what they're working on. Maybe they want to go just before it has some kind of use. And in some markets, you can't have a non-compete agreement. So that's another area. And the third area is trade secret theft. If you can't acquire the technology legitimately, then you may see greater interest in acquiring it illegitimately, like through trade secret theft. Another last point to mention is to the extent that what constitutes controlled technology is based on public disclosure, then you've created a perverse incentive to disclose early. You know, you have some early stage technology, you don't know the use, you may have a good faith concern that there is no potential defense application or of any significance. Give a speech on it. It's now in the public domain, and if the threshold test is whether it's been publicly disclosed, now that technology can be invested in with perhaps less fear about violating these other provisions. So this is actually a pretty technically complicated area. Determining whether something is publicly disclosed is the domain largely the patent office, 12,000 people, scientists and engineers. And it's also one that's fraught with risks because you're regulating things that have tremendous potential commercial use, may not have any immediate use, may have lots of uncertainties around it, and cutting back on collaborations, so you're reducing efficiencies of cooperating with other companies anywhere in the world that may be already doing the same thing. So there's also a downside cost to this. All of this makes it a very difficult dam, if you will, to construct in the appropriate way.
All right, Mark Cohen, thanks so much for taking the time to talk.
My pleasure. Thank you.